Welcome to the law offices of Chris M. Ingram's Immigration Podcast. Today we are excited to start a brand new 4-part series on the L-1A and L-1B visas. We are having a great time presenting these U.S. visas with you. We hope you are enjoying them too. The L-1A and L-1B visas offer excellent opportunities for business professionals to be transferred to the U.S. to either establish a new branch of a foreign company or transfer talent to an existing U.S. branch. Moreover, we also cover how these visas provide a pathway to obtaining a green card. Okay, so let's dive in. Before we begin, we'd like to thank attorney Chris M. Ingram and his team for their diligent work in researching and preparing the legal research for this deep dive. Also, please give us a like or follow, and better still, subscribe to this channel, as all of these actions really help us a lot, so thank you. Disclaimer. Please do not consider any content on our channels as providing you with legal advice. If you would like a free consultation, please go to www.breakthroughUSA.com. All right, let's unpack this. Today we're cutting through some of the complexities surrounding the L-1A and L-1B visas. You know, these aren't just bureaucratic steps. For global businesses, entrepreneurs, startup founders thinking about the U.S. market, well, they are really strategic gateways. Think of them as a kind of fast track for bringing your most essential talent, your key people, directly to where they're needed in the U.S. And crucially, without having to navigate the often very lengthy process of recruiting entirely new local hires from scratch. It's really about leveraging the expertise you already have and, accelerating growth. Our legal team here, including attorney Chris M. Ingram, they've been navigating these intricate intra-company transfers for, well, over 2 decades now. So they've really seen it all. Okay, so at their very core, both the L-1A and the L-1B visas, they're designed to facilitate the temporary transfer of employees. That means moving someone from a foreign entity, maybe an established office in Dublin or a thriving R&D center in Seoul, directly to a U.S. entity. The key is both operations have to be part of the same overarching corporate organization. That's critical.
So if your company has strong operations abroad and you're now looking to expand, maybe establish a brand new presence, or perhaps significantly strengthen an existing one in the huge U.S. market, these visas offer a highly efficient path. They let you bring over those key individuals who really embody your company's institutional knowledge, its culture, its specific expertise. And it helps bypass some of the common hurdles and, frankly, lengthy processes you often see with other work visa categories. It's like a direct pipeline for your proven talent.
And what's truly fascinating here, and maybe a bit surprising to people new to U.S. immigration law, is how this L-1 visa category handles the concept of dual intent. You see, while they are technically classified as non-immigrant visas designed for temporary stays, the L-1 is pretty unique. It explicitly acknowledges that someone coming to the U.S. on an L-1 visa can simultaneously hold the intention to pursue permanent residency, what we all call a green card. And they can do this while fully maintaining their temporary L-1 status. It's allowed.
That's quite a departure, isn't it, from what many people might expect from a temporary visa? Because with a lot of other temporary classifications, any hint, any indication of a long-term desire to stay can actually put your current status at risk. So what are some of the maybe common pitfalls companies fall into if they misunderstand this? Or conversely, what's a less obvious strategic benefit it provides?
That's a really good point. A common pitfall is exactly that, assuming that because it's temporary on paper, any talk or planning around a green card has to be kept quiet, almost hidden. But the reality with L-1s is USCIS actually permits this dual intention. It's built into the framework. And the profound strategic benefit for businesses, particularly those making significant long-term investments in their U.S. operations, is the security it offers. I mean, imagine committing millions to a new U.S. venture, transferring a really critical executive, and then suddenly their ability to stay long-term becomes uncertain just because their personal immigration goals evolve. Dual intent basically removes that constraint. It lets companies invest in their key people for the long haul, knowing that these individuals can potentially transition seamlessly to permanent residency if, the business needs and the individual's desires align down the road. This isn't just about flexibility. It gives this profound layer of stability for strategic planning. It helps ensure continuity of leadership or specialized knowledge without forcing an impossible choice on the person or the company. Our legal team, drawing on Chris's research, often points out that this unique feature really transforms what looks like a temporary move into a potential permanent asset for the company. It's a clear acknowledgement by U.S. immigration law that, well, global talent flows don't always fit neatly into temporary or permanent boxes. It means you can plan for that 5 or 7 year stay, and if things really take off in the U.S., that key talent can potentially stay on indefinitely.
Okay, so we've established the main purpose of L-1 visas and that fantastic flexibility dual intent gives you. Now, it's really crucial to understand that while both L-1A and L-1B visas handle these intracompany transfers, they are distinct. They serve very different strategic needs within a company. Getting these nuances right is absolutely vital for picking the right path for your specific situation, whether you're bringing in, say, a CEO to launch a new division, or maybe a highly specialized tech expert to implement some proprietary software. Right, let's start by unpacking the L-1A visa. This one is specifically tailored for executives and managers. Now, when USCIS looks at an L-1A petition, they're not just looking for a fancy title on a business card like director or VP. No, they're digging into whether the role truly involves managing other managers, or perhaps managing a major function or department of the organization. And critically, doing so with significant autonomy over decision-making and policy setting. It's really about the substance of the role. Is this person genuinely steering the ship, setting its course, making those high-level strategic decisions that impact a big chunk, or maybe even the whole, of the U.S. operation? They're expected to be defining goals, setting policies, and exercising pretty wide latitude in day-to-day operations and personnel matters. Okay, let's make this more concrete. Picture this scenario. Imagine Viridian Innovations, right? A flourishing AI and robotics startup based in Stockholm. They've just nailed a big Series C funding round, and they're eyeing the U.S. market, probably Silicon Valley, for their next big growth phase. Their visionary CEO and co-founder, let's call her Dr. Astrid Nilsson, she's been the absolute driving force behind their unique machine learning algorithms and their global strategy so far. Now, without a smooth way to transfer Dr. Nilsson, Viridian Innovations faces a huge problem. They could hire an entirely new, unproven U.S. leadership team, but that risks a major disconnect from their core company culture and their valuable IP. Or they could try managing the U.S. launch remotely from Stockholm, but that would seriously hinder the crucial on-the-ground strategic leadership and quick decision-making needed for a fast launch. The L-1A visa, it's the perfect solution here. It allows Dr. Nilsson to transfer as the CEO of Viridian Innovations USA. This gives her the legal standing, the authority to replicate their Stockholm success right there in the U.S. She can then personally oversee building strategic partnerships, hiring the initial U.S. team from the ground up, and making sure their American operations truly reflect the original company's values and vision. This dramatically accelerates market penetration and ensures that continuity of strategic vision. This kind of hands-on, high-level leadership from someone who intimately knows the company's DNA, that's precisely what the L-1A is designed for. It's more than just managing. It's really about leading this strategic direction.
And that strategic capability, well, it's profoundly important for any business aiming for global leadership. It really is. The ability to transfer proven executive leadership is just absolutely vital for successfully establishing or scaling U.S. operations. New ventures, or even existing ones facing a big pivot or a major growth push, they require strategic oversight, especially from people who are already deeply familiar with the company's culture, its proprietary ways of doing things, its specific goals. You're essentially trying to replicate success, right? And often that success is embedded in the leadership. So bringing over an L-1A executive ensures you get consistent strategic direction, and it minimizes that steep learning curve and the cultural integration challenges that inevitably come with hiring someone totally new from the outside. Attorney Chris M. Ingram's research really underscores this, highlighting how critical it is for maintaining consistency in a global brand. It ensures the U.S. operations are built on a really strong foundation of established leadership, fostering a unified global identity, and crucially, protecting intellectual property by having a trusted leader right there at the helm.
Okay, now let's shift gears over to the L-1B visa. This category is designed for employees with what USCIS calls specialized knowledge. Think of these individuals as the intellectual powerhouses, the experts whose unique understanding of your company's specific products, processes, services, maybe technologies, is genuinely irreplaceable. Now, this isn't just general expertise in a field like knowing how to code in Java. No, it's a proprietary or at least an advanced understanding that gives your specific company a distinct competitive edge. Knowledge that you wouldn't easily find just by posting a job ad.
Exactly. When our researchers, drawing from Chris's work, talk about knowledge being irreplaceable or specialized, they mean something that goes well beyond standard industry skills. It's a deep, often proprietary understanding of the company's specific offerings or methodologies. This could be, say, an intricate, internally developed manufacturing process, or maybe an intimate knowledge of a custom-built software system that took your team years to develop. Or it could even be highly specific market insights derived from years working within that particular company's unique operational framework. USCIS looks for knowledge that is either highly unusual, beyond the common knowledge in that industry, or specifically proprietary to the company petitioning for the visa.
There are just too many visas out there, and I don't know which one is right for us. We need to get the right advice.
Communication is everything, and I just need someone who will listen and guide me to the right visa type, and not make promises that they can't deliver.
There are so many documents. I need someone to walk me through each one. I can't afford to make any mistakes.
If I can just find a lawyer who understands my potential, I know America will be an excellent opportunity for me and my family.
Welcome to the law offices of Chris M. Ingram, and we are your immigration lawyers, and we will be with you every step of the way in your immigration journey.
At the law office of Chris M. Ingram, you get a free consultation so we can understand your needs.
We don't make promises we can't keep. Our success rate speaks for itself.
Join us and access your step-by-step video guides that answer every visa question.
Their platform is amazing. There are videos that instruct you on everything you have to do. It meant we were in control and we could do it in our own time.
They couldn't have been more helpful. They answered every question that I had, and it was easy to see they were the lawyers for me.
I couldn't believe it with my busy schedule. They always had time to talk to me and put me at ease. That's what I like about them.
So go on our website and get your free consultation now, and your new life is about to begin.
Ask me.
We did it! We did it! We did it!
Oh my God, I got my visa! Yes, I did it!
Let's illustrate this one too. Consider Quantum Logic, maybe a growing biotech firm based in Zurich. They've developed a patented cell culturing technique that dramatically improves the yield and purity of specific therapeutic proteins. It's complex, it's proprietary, it's central to their whole product pipeline. Their lead research scientist, let's call him Dr. Elias Brandt, was instrumental in developing this technique. He's basically the only person who truly understands all its intricate nuances and how to troubleshoot it when things go wrong. Now, if Quantum Logic wants to set up a U.S. R&D facility to bring these therapies to the massive American market, they face a huge challenge without Dr. Brandt. Hiring a new scientist, even a brilliant one, would mean months, maybe even years, of trying to replicate this highly specific in-house expertise. That could cost millions and delay vital product launches. So the L-1B visa allows Quantum Logic to transfer Dr. Brandt directly to the U.S. He can then personally oversee the setup of the new U.S. lab, transfer his intimate knowledge of that critical cell culturing technique to the new U.S. team, and ensure the quality and consistency of their protein production right from the start. This isn't just about hiring a scientist. It's about retaining and leveraging the very core of what makes Quantum Logic competitive, its proprietary innovations. Our research specifically highlighted an example, in the tech industry. An L-1B might involve a developer with intimate knowledge of a custom AI framework, something no external hire could possibly replicate quickly. It's not just knowing Python, it's knowing your company's specific, highly complex, unique AI framework that took years to build internally and gives you that significant market advantage.
Absolutely. And the strategic significance of the L-1B really lies in its ability to protect, transfer, and leverage that unique institutional knowledge. In today's markets, which are, let's face it, hyper-competitive and evolving incredibly fast, especially in sectors driven by innovation like biotech, specialized manufacturing, custom software, losing or failing to transfer this kind of knowledge can be, well, devastating. It's not just about filling a job opening. It's about retaining the very essence of what makes a company competitive. Often, it's their primary intellectual property we're talking about. By allowing the transfer of these specialized experts, companies can ensure continuity in their complex operations. They can accelerate R&D cycles and, crucially, maintain that competitive edge. Without the L-1B, they'd face the really daunting, sometimes impossible task of trying to recreate that highly specific in-house expertise. That can be an enormous barrier to global expansion and innovation. It directly impacts a company's ability to actually monetize its proprietary innovations in lucrative new markets like the U.S.
Okay, so we've really broken down the distinct roles for each visa type, the L1A and the L1B. That's clear. Now let's shift focus a bit to the practical side of things. The aspects that directly impact both the individual employee being transferred and the business itself. Because understanding these logistics, the benefits, it's crucial for realistically planning your global expansion strategy. So what does this all mean for you in terms of say how long someone can stay, what prior employment is needed, and the benefits for families, which are often overlooked.
Right. One of the most significant practical differences between L-1A and L-1B is the permitted duration of stay in the U.S. And this offers critical insights for long-term strategic planning. For an L-1A visa holder that's the executive or manager, you can typically get an initial period of up to 3 years. And then, through extensions, you can potentially stay for a maximum total of 7 years.
Yeah, that 7-year duration for the L-1A is incredibly substantial. It's quite strategic for building and really stabilizing significant U.S. operations. It provides plenty of time for a foreign company to establish a really robust presence, penetrate the market effectively, and ensure their executive leadership can actually see through long-term strategic initiatives, from initial market entry maybe all the way to market dominance. It signals and it enables a deep commitment to a lasting U.S. presence. It allows for multi-phase expansion, the maturation of the business here, and developing a sustainable leadership pipeline within the U.S. Unlike some visas that only allow for a few years, 7 years means you're not just kicking off a project. You're building a significant, lasting part of the company's future here. It allows for that crucial continuity in leadership through potentially complex economic cycles or unexpected market shifts.
Okay, and in contrast, the L-1B visa, the one for specialized knowledge employees, typically offers that same initial 3-year period, but with extensions allowing for a maximum stay of 5 years total.
Right. And while 5 years might sound shorter than 7, it's still a very substantial period, especially for transferring highly specific, often proprietary knowledge. And importantly, for effectively training U.S. teams to absorb and apply that expertise independently. This duration kind of reflects the L-1B's focus on more targeted knowledge-based roles. The primary goal might be embedding a unique process or transferring a proprietary technology or training up a local team to take over that specialized function eventually. It's generally ample time for that knowledge transfer to be successful and for the U.S. entity to become self-sufficient in that specific specialized area. Both these durations, the 7 and the 5 years, they seem carefully calibrated to cater to the different strategic needs of businesses. From the long-term executive oversight needed for holistic growth to the more focused, perhaps project-based knowledge transfer necessary for keeping that competitive edge through specialized expertise. Our legal team often spends time helping clients map out their U.S. expansion timeline against these visa durations to make sure everything aligns properly.
Now let's talk about a really critical non-negotiable requirement that applies to both L-1A and L-1B visas. That's the 1-year prior employment rule. This rule basically mandates that the employee you want to transfer must have worked for the foreign entity, the one abroad, for at least 1 continuous year within the 3 years immediately before they plan to enter the U.S.
Yes, this 1-year requirement is absolutely crucial. It's a point that attorney Chris M. Ingram always emphasizes based on our research and his experience. It's far from just an arbitrary timeline. It's designed by USCIS to verify the transferee's deep familiarity and established connection with the company's foreign operations, its internal culture, its specific expertise. The underlying idea is that this person isn't just some new hire with general skills. They are someone already deeply embedded in the company's unique way of doing business, maybe its intellectual property, its strategic goals. Think of it this way. You wouldn't typically trust someone who just walked in the door yesterday to lead a crucial, maybe confidential project that defines your company's future, right? So this rule helps ensure the person is already steeped in your company's DNA, so to speak. This requirement significantly reduces the risk of denials based on, say, insufficient experience or a lack of genuine intra-company connection. It provides clear, verifiable evidence of that pre-existing, substantial, meaningful relationship with the foreign entity. Without this proof, the petition is very likely to fail, leading to wasted time, effort, and money. Our team often sees petitions run into trouble when this continuity of employment isn't clearly and meticulously documented.
Right. So beyond these specific durations and the crucial 1-year rule, these visas, both the L-1A and L-1B, they really are genuine game changers, especially for entrepreneurs and startup founders who have global ambitions. They can truly accelerate market entry, foster that global synergy, and help protect a company's competitive edge. Let's take another specific example. Imagine Synapse Dynamics, maybe a cutting-edge AI startup based in Barcelona. They've developed a really groundbreaking AI-powered analytics platform for the financial markets. Their big goal is to enter the U.S. market, maybe targeting New York's fintech hub, to scale up fast and grab a competitive edge. An L-1B visa allows them to send their chief architect, the person with that intimate, deep knowledge of their proprietary AI algorithms and complex data integration methods, directly to the U.S. That person can then adapt the technology for the American regulatory environment, implement it locally for key initial clients, and start training a U.S. engineering team. This accelerates Synapse Dynamics' market entry dramatically, potentially shaving months, maybe even a year, off their timeline. And crucially, it lets them bypass the often uncertain and highly competitive lottery system of other work visas, like the H-1B. That can be a huge bottleneck, especially for innovative startups relying on very specialized talent. It's about securing your key talent on your preferred timeline. And for the larger, more established multinational companies, the L-1A visa in particular enables really seamless executive rotations. It allows for cross-pollination of leadership ideas and talent across their global offices. This isn't just about moving people around, it's really about fostering global synergy, sparking innovation, and maintaining a consistent brand identity worldwide. By having consistent leadership who are familiar with the company's global vision and overall strategy, these companies can ensure their U.S. operations are always aligned with their worldwide objectives. This drives consistent growth and integrated development across continents. It's a key tool for cultivating a truly global enterprise culture.
That point is so critical. As attorney Chris M. Ingram often notes from his decades of experience, and I'm paraphrasing here slightly from our research, the L-1 visas are essential for businesses aiming to maintain continuity and competitive edge in the U.S. By allowing the transfer of proven talent, they prevent the loss of institutional knowledge that could otherwise derail expansion efforts. He adds, "In my experience, clients who leverage these visas often see faster growth and smoother integrations into the American market." That insight perfectly captures why these visas are much more than just immigration tools. They are fundamental business enablers. They directly mitigate that significant risk of a new market entry being hampered by a lack of internal expertise or understanding. They ensure that the unique operational DNA of the company's success is directly transferred and replicated in the new U.S. environment. It's really a strategic investment in human capital that pays dividends in speed, efficiency, and ultimately market penetration.
You finally got your family together on a H-1B. Your American dream begins. Your employer files for your EB-2 green card, but the wait is over 11 years. As the years go by, frustration grows, and now the company is talking about layoffs. This could be the end of your American dream. You search for help, but luckily, you land on breakthroughusa.com. They listen, reassured you, and built your EB-1 case with precision. Then one day, a notification buzzes, EB-1 approved. With your EB-1 green card, your entire family can breathe.
I have got my visa. I got my visa.
That's why the law offices of Chris M. Ingram is trusted. Your future shouldn't wait. Let's talk EB-1.
What are the next steps?
Need help with your visa? Book your free consultation now at www.breakthroughusa.com and let us take care of you.
And it's not just about the business side, is it? These visas also come with incredibly significant benefits for the transferees themselves, and importantly, their families. This is a huge factor, often underestimated when you're trying to convince top talent to make a major international move. Both the L-1A and L-1B visas extend benefits to the immediate family. This means spouses, they get what's called an L-2 visa, and unmarried children under 21 are allowed to join the main visa holder in the U.S. This isn't just a small courtesy, it's really a foundational element in making a successful international transfer feasible for these highly qualified professionals.
Absolutely. That family inclusion is incredibly important. It supports work-life balance and makes these international assignments a viable and frankly attractive option for top-tier executives and specialized professionals. Let's be honest, without the ability to bring their families, many would simply decline the opportunity, which would be a significant loss for the business trying to expand. Furthermore, and this is a highly significant aspect, a major draw for L-1 visa holders, is that spouses on the L-2 visa are often eligible to apply for work authorization in the U.S. It's commonly called an L-2 EAD, Employment Authorization Document. Now, this isn't automatic with all visa categories, so it's a huge relief for many families. It allows the spouse to pursue their own career, contribute to the family's financial well-being, and it significantly aids in their overall adjustment and integration into life in a new country. Our researchers confirm that recent updates have even streamlined the process for getting this spouse employment authorization, making it easier and faster for families to really thrive here. It reduces a lot of the stress associated with such a major international move. This comprehensive support for families truly helps companies attract and, just as importantly, retain the best global talent they need for U.S. success. Okay, now, as we transition to what our team really considers the absolute fundamental requirements for a successful L-1 visa application, it's vital to stress that these are, well, non-negotiable foundations. Many excellent candidates, many strong business plans, unfortunately falter right here because of inadequate preparation or documentation. So this raises a really important question. Beyond the individual employee's qualifications, how does a company unequivocally demonstrate the fundamental legitimacy and the sometimes intricate corporate structure required to even use these visas effectively? This is really where the rubber meets the road in an L-1 petition. The absolute key to leveraging L-1 visas, and honestly, the very first hurdle USCIS examines closely, is demonstrating a genuine qualifying organizational structure. This isn't just some formality, it's the absolute bedrock of the entire L-1 category. It means the foreign entity and the U.S. entity must be related in one of 4 very specific ways. They have to be either a parent company and subsidiary, or 2 affiliates, or a branch office relationship. And each of these relationships has specific legal definitions and, crucially, specific evidentiary requirements. For instance, a parent company typically needs to own more than 50% of the voting shares of the other entity, the subsidiary. An affiliate usually means 2 entities are under common ownership and control, perhaps by a third entity, or maybe owned by the same group of individuals in roughly the same proportions. A branch office is simply an operating division of the same company, not separately incorporated. Proving this structure clearly shows U.S. Citizenship and Immigration Services, USCIS, that the foreign and U.S. entities are indeed part of the same corporate family, operating under common ownership and control. Without clear, meticulous, and compelling evidence of this relationship, things like detailed articles of incorporation, stock certificates showing ownership percentages, partnership agreements, clear organizational charts, financial statements demonstrating the ownership links well, proving eligibility can be extremely challenging, if not impossible. Our team's legal research looking at past cases and USCIS trends highlights that many RFEs, those requests for evidence, and even outright denials stem directly from insufficient or confusing documentation of this fundamental corporate linkage. It's simply not enough to say the companies are related. You absolutely have to prove it with a solid paper trail.
Okay, so it's not just about having a similar name on the door. It's about that clear, demonstrable, legal, and operational connection. That makes perfect sense. But what about the actual business operations themselves? Is just having the structure enough? How does the USCIS assess whether these are real, active businesses? What kind of ongoing activity needs to be shown?
That's exactly the next critical piece. Beyond just the structure, USCIS requires clear and substantial evidence of ongoing business activity in both the U.S. and the foreign country. It's a common misconception that simply having a registered business entity, maybe a mailing address, is enough. It's absolutely not. Both the foreign entity and the U.S. entity must be actively engaged in providing goods or services on a regular basis. They must be actively doing business. And doing business means regularly, systematically, and continuously providing goods or services. It's not just about passively holding assets or having a bank account. It's about active commerce, real operations. For the foreign entity, this means proving it continues to operate as a viable, going concern. You typically show this through comprehensive financial statements, corporate tax returns, examples of active contracts with clients, recent invoices, payroll records demonstrating it has employees, maybe lease agreements for its premises. USCIS wants to see a vibrant, active business abroad that can genuinely support an intracompany transfer. Now, for the U.S. entity, especially if it's what's called a new office, meaning it's been operating for less than 1 year, the requirements are slightly different, but certainly no less stringent. You have to demonstrate a genuine need for the transferred executive or specialized knowledge employee. You need a clear, concrete business plan outlining planned active operations. And very importantly, you must show the financial ability to actually commence and sustain that business. This usually includes having secured physical premises like an actual office lease, not just a virtual address mailbox. It requires a detailed business plan with realistic revenue and expense projections. You need evidence of sufficient capitalization money in the bank. And often, a clear, tough line for hiring additional U.S. staff is expected. Our attorneys constantly stress that without solid evidence covering both the ongoing business activity and that qualifying corporate relationship, getting approvals can be incredibly challenging. It often leads to prolonged delays, difficult requests for evidence, or even outright denials. For example, a common pitfall we see, especially with new U.S. offices, is submitting insufficient proof of adequate physical premises, or failing to demonstrate enough financial backing to realistically pay the transferee's salary and actually start operations as planned. The thorough preparation of this legal research, making absolutely sure all the ownership documents, the financial records, the operational reports are meticulously compiled, organized, and clearly presented, is just paramount. This level of detail is what ensures the petition can stand up to the intense scrutiny it will receive and clearly demonstrates the legitimacy of the entire corporate structure and its ongoing activities.
Wow, okay. We've covered a lot of ground in this first part of our deep dive into L-1 visas. We've really tried to lay the essential groundwork here for understanding both the L-1A and the L-1B visas, framing them not just as visas, but as vital bridges for bringing international talent into the U.S. We've explored their core purpose. We dug into that powerful and maybe surprising concept of dual intent. And we worked hard to clearly distinguish between the executive and manager focus of the L-1A and that specialized knowledge requirement for the L-1B. We also got into the practicalities, like the different durations of stay 7 years versus 5 years, that crucial 1-year prior employment rule, and the really significant business advantages and comprehensive family benefits these visas offer. And just now, we highlighted the absolute foundational importance of demonstrating both a genuine qualifying organizational structure and real ongoing business activity for both the U.S. and foreign entities. So as you consider these powerful visa options, maybe for your own global operations or perhaps your entrepreneurial dreams, here's something to maybe mull over.
How might proactively identifying key talent within your global operations right now, understanding their specific roles, their unique knowledge, and then really mapping their fit within these distinct L-1 visa categories, how might that prepare you not just for a seamless U.S. expansion, but for a truly accelerated one in the future? Really leveraging this L-1 visa framework to its fullest strategic potential. It's about thinking ahead, right? And maybe transforming what look like bureaucratic hurdles into clear pathways for growth. Okay, that brings us to the end of part 1 of our 4-part series. And next time, in part 2, we're going to take an even deeper dive, specifically into the L-1A visa, the one for executives and managers. We'll explore its eligibility criteria in even greater detail, highlight its specific benefits for businesses looking to lead from the front in the U.S., walk through some more real-world scenarios, and share further insights from attorney Chris M. Ingram on how these visas truly empower executives and managers to drive U.S. growth and transform global strategy into local success. So definitely join us for that. Thank you so much for being with us today.
We really hope you gained a lot from this discussion. Please subscribe to or follow this channel, as it can significantly increase the reach of this deep dive series and help us help more people like you. We'd greatly appreciate your support. And hey, leave us a comment if you can. We do read them. Also, follow us on YouTube, LinkedIn, Facebook, X, and Instagram. We're growing rapidly on those platforms thanks to our dedicated social media team. We would also like to thank attorney Chris Ingram and his dedicated team once again for researching and preparing all this detailed legal research for our presentation today. And remember, if you, a friend, or maybe a family member would like a free consultation regarding U.S. immigration options, you can visit our website at www.breakthroughusa.com and schedule an appointment. We'd love to hear from you and help you if we possibly can. Bye for now.